Hey everybody, welcome to class today. So this class revolves around the Deer Valley case. Like I said in class, this is probably the first time that many of you have ever read a legal opinion before. So I've pulled up the case here so you can, really so we can walk through it together. I think that's going to be one of the best things that that we can do right now. And I'll point out things that are important, what to look for, how to annotate the case as you read, and then how to go about thinking about what the case means, um, with some insights that I have about this case itself. So, all right, how do you read a case? Okay, so first off, something that I like to do is highlight the names of the party. Now, I've already called this the Deer Valley case, so if you'll see here, we've got the name of the plaintiff, Deer Valley. The plaintiff always comes first, followed by the defendant. Gets a little mixed up on appeal sometimes, but let's not worry about that. All right, so we've got Deer Valley. And then for simplicity's sake, normally you only name the first defendant listed in the case. So here we've got lease one. So if we were talking about this in class, we would just say the Deer Valley case or Deer Valley versus lease one. But there's lots of defendants here. You've got Joseph, Angelo, and usually you just go by last name. So we've got Angelo, Lopez, First Financial, and Cersei. All right, those are all going to be the defendants. Interesting. This is going to be found in the U.S. District Court. If you ever see that U.S. Let's make this underline here. If it's in a U.S. District Court, that means it's a federal court. Otherwise, it'll say State of Idaho Trial Court or something to that effect. All right, this took place in 2013. Decided, 2013. Okay, so as we move through this, so I got this off of LexisNexis. LexisNexis does this interesting thing where they've got core terms. You can peruse through that to see what the main elements of this case are. What are the most important things going on here? I always like to look for who the attorneys are, so I know a lot of these people. And I used to work at the same firm as Jared Allen. He works for Beard St. Clair, and so I know Jared. Interesting fact is that I actually know all of the attorneys here. So Ryan Destin, he was working at Thompson Stevens at the time. He started his own firm since 2013, but he and I graduated law school about the same time. And then Marvin Smith was my Sunday school teacher in my ward in Idaho Falls when I was clerking for the summer there at a different firm. Really interesting, kind of fun things. Judge Windmill received a promotion after this. So he left Pocatello and now he works with the Ninth Circuit, but with the Ninth Circuit offices. You don't need to know any of that. But Judge Windmill is a really interesting case. Fascinating person. I've never met him personally, but I've never heard anybody say anything negative about this judge. He grew up in Pocatello, went to Idaho State. He was the first, and as far as I know, the only person to go to Idaho State and then to Harvard Law School. Had offers all over the country and international, I think, but decided to go back to Pocatello, opened a small practice, is seen as just highly ethical, a great person. It was Bill Clinton, President Clinton, that appointed him to this position with the federal court system. And it was just unanimous. Like I said, this is a great story and a great person as far as I know. So again, little tidbit, something that you might not have known about while you were reading this case. All right, so now we get into it. This is exciting. All right, we're gonna read a case. I'm giving away my nerdiness here, but this is kind of fun. So Judge Windmill, also a great writer, / his clerks are a great writer. what I mean by that is after law school, most attorneys either go into private practice, work at big firms, or a lot of them do clerkship. So they'll go work for judges all over the place, and getting a federal clerkship is a fairly prestigious first job opportunity. So anyway, lots of the clerks end up writing the opinions. The judge tells them what to do, but then they put it together. All right. Anyway. All right. So the question before the court is whether to transfer this case to the U.S. District Court for the District of Massachusetts. All right. Remember, they're in Idaho. Should we send this off to Massachusetts? Another way of saying this is, did we pick the right jurisdiction for this case? Now, I've already told you this is in federal court, so we have to meet all of those requirements that we talked about in the last class. Personal jurisdiction, subject matter jurisdiction, venue, all of that. And what's interesting here is that we've met the personal jurisdiction, we've met the subject matter jurisdiction because of diversity jurisdiction. We'll get into that. The question is this the right venue? Should it be in this federal district court, or should we send it off to Massachusetts? What's going to be more appropriate? Okay. So excited. All right. So because a transfer would do little, if anything, to lessen the cost associated with this litigation or serve the interest of justice, the court will not upset plaintiff's choice of forum. Meaning it's going to stay in Idaho. And interesting, let's find out why. And especially, there's some complications here that make this very interesting. All right, so continuing the introduction, here's some background information. So Deer Valley is an Idaho corporation headquartered in Idaho Falls. Important. All right, and remember, all plaintiffs have to be to get federal jurisdiction. You're going to need all the plaintiffs to be from different states than all the defendants. So that's why Judge Windmill is going through this right here to establish that. All right, Deer Valley provides trucking and transportation services. He was contacted by Joe, a Utah broker with the defendant Lease One. Mardish began negotiating with Deer Valley over the lease of 100 vacuum trailers. These are those trailers that you see going down the highway, trucks designed to transport oil. All right. Great. So Joe is down in Utah, but he's negotiating for Lease One. Lease One. Well, let's keep going here. All right. He got those initial disclosures. He turned the negotiation over to Lease One's president and defendant. So this is where Angelo comes into play here, and Lopez. So now we've got, probably important here, there in Massachusetts, Lease One proposed to pay $5.4 million to lease the vacuum trailers at a promising interest rate. You accountants are like, what is a promising interest rate? And that's in quotes, so that was part of the deal. Interesting. Okay, in addition to monthly payments, Deer Valley was required to provide a non-refundable down payment of $344,000. If you're asking yourself, why would Deer Valley make a down payment in order to get paid $5.4 million, then you're asking the right question. What is that? Look, what on earth is Lease One doing here? And if this looks like a scam to you, good for you. This is probably a scam. All right, the non-refundable nature freaked out Deer Valley. So they had this conference call with everybody. And this is important. Angelo assured Deer Valley that the down payment was only non-refundable if Deer Valley got the financing and then didn't go through with the deal. Okay, great. All right, let's move on here. And now we've got the actual terms of the agreement itself. So the court doesn't just attach the contract to the opinion. They'll go ahead and like say, here are the important parts of the opinion. And that's what this is. And you probably picked out a lot of these important things, but this lease shall be deemed fully executed and performed in the state of Massachusetts. All right. And this lease shall be governed by and construed in accordance with the laws of the state of Massachusetts. Good. And this is what is interesting. Deer Valley expressly and unconditionally consents to the jurisdiction and venue of any court in the state of Massachusetts and waives their right for jury or claim of action in it anywhere. Okay, and this form non-convenes, that just means Deer Valley, the Utah Corporation, can't say, yeah, Massachusetts is inconvenient for us. Therefore, we have to do it in Idaho. Deer Valley agreed to all of this. This was part of the contract. They said, yeah, well, if we need to sue you, we'll go to Massachusetts. Okay, I'm so excited. Okay, now this is where the dispute really kind of hits the fan in the sense. The parties disagree to why, but Lease One did not provide the financing to Deer Valley that it promised, right? What that means is Lease One is going to say there's some other reasons why it didn't provide all of that. And that's in dispute. But at the end of the day, they didn't finance the endeavor. And so Deer Valley sues. Deer Valley, at this point, interestingly, important lesson here. If you're a business making major contracts, talk to a dang attorney before you do this. This could have saved some real consternation. But at this point, now Deer Valley sees that they've got a major problem. They go to Jared Allen, and they say, hey, we need some help. We might need to sue somebody. Jared Allen goes through this contract, and he's like, my goodness, why did you not talk to me beforehand? But water under the bridge, let's sue him. And Jared sees the contract and it says you can only sue him in Massachusetts. And Jared says, screw that, we're going to sue him here. And interestingly, they sued right here. This is important. Jared Allen, his offices are just down the street from the state courthouse in Idaho Falls. And he says, let's sue him in Idaho Falls. Let's sue him here in the state court. Why? Because remember, state courts are desperate. They'll take anything. And so there's very few barriers of entry into the state courts. So he sues him there. Very convenient for Deer Valley and Jared Allen. But then you'll see here, what happened was, Lease One and the other defendants were like, yeah, we don't want to be in state court. We'd rather be in that beautiful marbled federal courthouse down in Pocatello. And we meet all the requirements. Remember the requirements: personal jurisdiction, that's simple, and subject matter jurisdiction. This isn't a federal question because it's breach of contract, firmly within state law context. But we've got diversity, right? All the plaintiffs and the defendants are from different states. It's relatively easy because the plaintiff is just from Idaho. Lease One and these other parties are from Massachusetts. So they can get it into the federal courthouse in Pocatello with the plan of this. Once you get it into the federal courthouse in Idaho, then you can transfer it over to the federal courthouse in Massachusetts. Interesting, my buddies here, Dustin and Marv Smith, they're representing lease one, and who's Dustin representing? Okay, so it's Ryan Dustin that's representing lease one, and the bank, First Financial Brokerage, the New Jersey corporation, was represented by Marv. Um, they're basically just taking this case, getting paid money. Their only purpose of taking the case is to get it out of Idaho so that they can't work on it anymore. Like once they get it approved by Judge Windmill to get it transferred over to Massachusetts, then they can like wash their hands of it and be done. Interesting strategy. Let's see how it works. My goodness. Yeah, we're still on page 2. Okay, I'm going to calm down here. Now, of all of these parties, my former co-worker at Beard St. Clair, Jared Allen, is like, I don't want this to go to Massachusetts. If it goes to Massachusetts, I'm out of a job, right? It goes somewhere else, and I don't get paid. So part of it is personal, and I love when Jared comes to the class because he'll say this. He's like, I like money, and I wanted to keep this case, so I'm going to try to push to keep it here in Idaho. And that's what Deer Valley wanted anyway. They're located right there, kind of close to Jared's office, and so and they trust Jared. And so again, he's pushing to keep it there. They're trying to get it moved across the country. Now, normally, if the contract says you got to bring the lawsuit in Massachusetts, courts are going to accept that, and courts are going to let you move it across the country to Massachusetts. Why? Well, Deer Valley, you signed a contract that says that you would do that. Okay. But Idaho has, and normally without taking this class, you probably think, yeah, we're screwed. We better send this off to Massachusetts. But Idaho's got some interesting things. And Jared did a lot of research and figured this out and submitted this in his brief to Judge Windmill. Some pretty dang good arguments about, even though Deer Valley agreed to move it, Idaho law has some precedent, some other case law that says that we should keep it in Idaho. So here we go. In the discussion part I'm reading here, as such, for the convenience of the parties and witnesses and interest of justice, a district court may transfer any civil action to another district or division where it might have been brought, or to any district or division which all parties have consented. That's a big red flag, because all the parties did consent in the contract. However, transfer should not be freely granted because there's a strong presumption in favor of the plaintiff's choice of forums. Here, the forum would be Idaho, and the plaintiff is Deer Valley. Let's keep it in Idaho. This is right here. What this means, that's the case citation, this 2003 federal case that says, let them keep it where they want to keep it. Okay. Yeah. And yeah, defendants must make a strong showing of inconvenience to warrant upsetting the plaintiff's choice. And defendants say they didn't make that, but the judge is going to disagree. Spoiler alert. All right. Okay, and then this is where things get really important. The court's decision to transfer a case is based on considerations of convenience and fairness. And then here are the important considerations that a judge has to weigh to determine whether or not to move it or not. You can see here the locations where the relevant agreement were negotiated and executed. Where did that happen? Remember, the contract says that it happened in Massachusetts, but the judge is going to call baloney on that. The state that's most familiar to the governing law, well, the governing law is going to be Massachusetts, so maybe that means let's move it. The plaintiff's choice of forum, Idaho. The respective parties' contacts with the forum. That's kind of up in the air. Anyway, the Judge Windmill is going to go through each of these, and that's kind of what we get to next here. Yeah, much of defendant's argument rests on the lease agreement titled law that we talked about earlier, saying Massachusetts. Yeah, the sentence that governs the suit of the transaction is meant to help tip the scales in a venue contest, as defendants' reliance on it plainly shows. Okay? However, its weight is significantly diminished in this case because Idaho has expressed a strong public policy against the enforcement of form selection clauses. If some of you are confused by this, be confused. This is uniquely Idaho right here. Idaho says, yeah, you signed an agreement that says that you got to go to Massachusetts to bring your lawsuit, but we're Idaho. Screw that. This is really interesting to me. And this is the law that Jared found, cited, and quoted to Judge Windmill. And Judge Windmill's like, yep, this is the law in Idaho. It's going to end up staying here in Idaho. This is really interesting. Okay. Moreover, the court does not agree that the citus sentence and the governing law sentence in the law clause support transferring the case under the second and fifth factors. And if you jump back here, you see the second one was the state that's most familiar with governing the law. And Judge Windmill's like, we can read the Massachusetts Code of Breach of Contract. It's basically the same as Idaho. And we're just as familiar with that as Massachusetts is his reasoning there. And number 5, the contacts relating to the plaintiff's cause of action in the chosen form, meaning the people that are involved in this case, they're in Idaho too. So Judge Windmill's going to say those two aren't really going to weigh in favor of the defendant as much as the defendants wish that it did. Oh, I love this. Okay. Yeah. And then, and this is important. Okay. It's this paragraph here. So we just talked about that. However, Deer Valley's contract claim is 1 but 7. And the remaining claims are largely unrelated to the contract claim. So yeah, the contract claim, Judge Windmill says, that's Massachusetts law. We can read that and figure it out. But many of the claims that that Deer Valley brought were based on fraud, unjust enrichment, racketeering, and many of those will be based on Idaho law. So the contract claim, sure, we'll look at Massachusetts law, but fraud and everything else that wasn't covered in that law section in the contract, it's actually going to be governed by Idaho law. So yeah, looking at kind of the rest of this, the rest of this we can kind of jump through fairly quickly. It's just interesting, especially here. Idaho has the stronger ties to the underlying contract. That's probably true. A lot of it was negotiated over the phone, and Deer Valley was always located in Idaho. So we've got plenty of contacts here in Idaho. Let's keep it. As far as this, defendants were saying, well, there's multiple of us parties on the East Coast, so it's easier if you move it over. And Judge Windmill's not having any of that. The fact that the defendants outnumbered Deer Valley is an insufficient reason to transfer the case. So we're going to keep it here. And this is important. After balancing the relevant factors, you're going to see this much throughout this course. The law isn't like a straight, in this case, you should always transfer the case to another state, or in this case, you'll always find copyright infringement. Instead, the court creates a balancing system, hence the common image of the law being the scales, the weighted scales. And that's what Judge Windmill did here. He's like, I looked at these 7 factors. We're keeping the case in Idaho. So there it is. Deer Valley wins. Jared Allen got a win. And they're going to go forward with a trial here in Idaho. Okay, let me stop sharing here because we're kind of done with that. And you may think like, congratulations, Jared, you did it. Jared will say, he won this battle, he lost the war. And this is very interesting and very important to understand with lawsuits. I think I hinted in class once, I've done one jury trial. I've taken one, I've appeared before many, many hundreds of judges, but I took one case to trial. And it was with Lance Schuster. He also works at Baird St. Clair with Jared. And it was when I was in my first year of practice before we went to Florida. And this was a construction defect case. So we represented a couple. They lived in Blackfoot, Idaho, built this multi-million-dollar home on the river, lots of land, a huge greenhouse so they could grow banana trees. I mean, this was amazing. And there were some problems with the construction. So we brought a lawsuit against the construction company. They fought back. We went to jury trial and we won. Congratulations. Like, anyway, this is exciting. I got to do some cross-examination and Lance let me help. I was second chair, just meaning he's the primary attorney on it. He had 15, 20 years experience. I had like 6 months. And so anyway, he was kind enough to let me help out. But I did a lot of the briefs to the judges with all the pre-trial hearings and everything else, but he was in charge. Anyway, we go through this trial. It took about a week, and we win. We win the trial, and what happened was the day after we won the trial, and we got a judgment against the construction company. They filed bankruptcy, and we got nothing. We won, but we lost. And that's very similar to what happened here with Jared Allen. They won, but then Deer Valley was in some severe financial straits. They transported oil. And if you remember, with the last recession that started in 2008, 2009, gone into the time when all of this was going forward in 2013, Deer Valley just kind of eventually ran out of money and couldn't continue this claim. Lease One looks like that they were just kind of running this operation where they would do something similar, promise $5 million to trucking companies, request 300 grand up front, take that, claim some breach or something, and then not pay them and then just have to get sued, because there were many. Jared found that there were lots of lawsuits against Lease One for a very similar set of circumstances. Anyway, what happened is Deer Valley couldn't pay Jared's legal fees anymore, and they never even got to the point where they could get this to trial. And this is very common. Trial is expensive. If you want to take something to trial, you're going to need at least 100 grand for legal fees for a major trial like this. I think you could get away with a small state court quick thing for around 10 grand if you find a budget attorney. But these things take a lot of time, and most attorneys are billing around here $300, $350 an hour, and that's cheap. Like I don't even want to tell you what New York, like my buddies that are still in San Diego or went out to New York or LA, they're billing $500 to $1,000 an hour. And so this is why in my business practice, I avoid trial at all costs. This part of it is, this is my well, you know about my first jury trial. It's just left a bad taste in my mouth. Our clients were really upset. Like we won the trial and then they owed us legal fees, but they couldn't get anything. There was no positive resolution for them other than paying us tens of thousands of dollars in legal fees. I understand that frustration. That's why that last slide of our last class was so important. Negotiation, mediation, arbitration. I don't even like arbitration or mediation. I just negotiate. And the way that you negotiate best for your client is you study the facts of the case, you figure out what the law says, and you go in with those facts and you say, look, here's what's going to happen in trial. Now you never really know, because like I say, often a jury trial is just a black hole of mystery. Like who knows what's going to come out of that. But if you do that and the facts are on your side, just negotiate something great. Now, if the other side's unwilling to work with you, you may consider a lawsuit, as Jared Allen tried to negotiate this and they wouldn't, basically daring him to bring the lawsuit. So he did. And they knew that Jared probably wouldn't get any money out of that anyway. But, no positive resolution for the clients. And yet Marv Smith, Ryan Dustin, and Jared Allen, they all got paid something, a little bit, to take this to trial and have a couple hearings in front of a judge. And then they never even really got to the trial because everybody ran out of money. Just a terrible, terrible set of circumstances. And one of the problems with the US legal system, how expensive it is. Access to justice is expensive. Prohibitively so. Most people just can't even afford to sniff a lawsuit in federal court. So something to think about. But I hope that you did enjoy this case. We'll have some more coming up next week. We'll talk about some business crimes and torts and accompanying lawsuits there. And anyway, you've read your first case, so it'll be a little bit easier next time. But I'm excited to get into that. So yeah, have a great day. I'll talk to you soon.